Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. I've received many questions regarding the pending motion to continue and the hearing that is coming up on June 18th, 2025. I wanted to first invite you to a live that we will be hosting this weekend on the 15th right here on this YouTube channel, where we will be discussing further the motion to continue the forthcoming hearing and other matters related to Idaho versus Kohberger. Everyone is invited. In order to address some of the questions that we have received, I wanted to go back to the basics of what is it that the defense has filed, what will be before Judge Hippler, and how has the state of Idaho responded. First, this is a motion to continue the trial date. It's not a motion to postpone. It's not a motion to delay. It's called a motion to continue. And you see these when one party or the other believes there's good cause to continue something, usually a hearing or in this case, a trial. The motion was filed by the defense on the 20th of May, and they set forth a number of reasons why there is good cause to continue the trial. If you have not yet had an opportunity to read that document, I very strongly recommend that you do. Now, a motion is an application for a court order. It is, in other words, a request for the court to grant what's called a remedy or relief, which is filed in the motion. Here, the relief sought is a continuance of the August 11th, 2025 trial, which was set by operation of Judge Stephen J. Hippler's October 9th, 2024 pretrial and trial order. There are typically 3 filings in the briefings on any motion. We've seen this with motions to suppress evidence, with motions in limine, with motions for a Franks hearing, and now motion to continue. The briefings consist of the initiating motion, response by the other side, giving them their due process right to be heard on the matter, and then what's called a reply, where whoever the initiating party is, here the defense, would have an opportunity to reply to the response. Not to re-argue the entire motion again, but limited to addressing what is in the response. And we see here that the state of Idaho did file a response. It is a response in opposition to the relief sought by the defense, which is a motion to continue. The state of Idaho does not want this trial continued beyond the date set forth in the October 9th, 2024 order, as the state of Idaho has said here. This date has been in place for some time. It's time for this trial to happen. That is their position. If you have not yet read the state of Idaho's response, please do. It is on the docket, as is the motion to continue itself for you to read. The reply has not yet appeared either on the case summary page or on the docket. We are looking for that document. Once it hits the docket or there's an indication it's been filed on the case summary page, we will advise you. Now, what can we expect to happen at hearing? Judge Hippler has said that this is an open hearing, so the public is invited if they wish to try to get a seat in person in Judge Hippler's courtroom. These are in-person hearings. There's 2 that are scheduled on June 18th, one of which is the motion to continue, which is open. The other is the motion on the defense's offers of proof of alternate perpetrators. Unfortunately, that is closed to the public. With respect to the motion that is open to the public, oral argument will commence sometime at 12:30 or thereafter. We can expect the first person who will speak will be the Honorable Stephen J. Hippler, who will call the matter to order. After saying a few words, as Judge Hippler does, he will then turn the podium over to the defense. The defense will speak first. This is their motion. They have one final opportunity at oral argument to persuade the judge to grant this motion, to enter an order continuing the trial. Then you can expect the court may have a question or two of the defense, and after the defense then sits down, Judge Hippler is going to turn to the state of Idaho, and they will have a floor and an opportunity to explain why the court should deny this continuance and allow the trial to proceed as it has been scheduled on October 9th, 2024, to start on the 11th of August, 2025. We can expect the court may have a few questions of the state, and once that portion of the hearing is done, the court will likely turn back to the defense. It follows the motion, reply, response sequence. And then once the defense rests, the court will do either one of two things. The court is either going to give a proclamation from the bench, as he has done in certain instances before. For example, during the very long hearing on the motions in limine, the court did rule from the bench for a few of the in limine motions. For others, he reserved ruling, saying that he would take matters under advisement. What's that mean? He's going to consider what the state has said, what the defense has said, and then he will issue a written order thereafter. So either the ruling is going to come on the 18th of June, or it will come sometime after the 18th of June announced in the written order. Whichever way the court decides to handle things, if it's a verbal proclamation from a bench, he will follow it up with that written order anyway. If you have any comments, please leave them here. If you like our content, I would greatly appreciate it if you could hit the like button, and if you have not yet subscribed to the channel, please do so, because things are happening very fast and very furiously now as matters are getting closer and closer to voir dire. This is Kathy. Thank you for joining us here today.